Sir, it is live. Pranoy, it is live.
Good evening to everyone joining us. On behalf of the Indian Law Institute, Kerala State Unit, I warmly welcome all of you to this discourse on the topic Presumption of Innocence, Constitutional Uncertainties. Over the years, as you would all know, the Indian Law Institute, Kerala State Unit has organized several lectures, colloquiums, and discourses, bringing together members of the bar, the bench, academics, and students to deliberate on important developments in law and constitutional thought. I would like to take this opportunity to acknowledge the guidance and support of Honorable Chief Justice Sri Shaun Singh, President of the Indian Law Institute Kerala State Unit, Honorable Dr. Justice A.K. Jayashankaran Nambiar, its Executive Chairman, and all other honorable judges and esteemed lawyers who are the Executive Council members, whose encouragement has been instrumental in the functioning and activities of the unit. The topic chosen for today's discourse addresses one of the most fundamental principles of criminal jurisprudence. While the presumption of innocence has long been recognized as a cornerstone of fair trial rights, contemporary developments in criminal law and procedure raise several important constitutional questions about its scope and application. It is therefore a subject that is both timely and deeply significant. Today's program is being live streamed, and those watching online are welcome to pose their questions during the session. We will take up the questions during the question answer session following the lecture. To begin the program, it is my privilege to invite Sri V.G. Harindranath Sir, Senior Advocate of the High Court of Kerala. Senior Advocate Sri V.G. Harindranath, before being designated as a Senior Advocate, had a distinguished and multifaceted career in the legal field. He served with distinction in the Kerala Judicial Service, rising to the position of District and Sessions Judge, and later as the Law Secretary to the Government of Kerala, where he played a key role in bringing in several innovative legislation. He is also widely respected as a voracious reader and an eloquent speaker whose insights on law and public affairs are deeply valued. May I now invite Senior Advocate Sri V.G. Harindranath Sir to deliver the introductory remarks. Over to you, sir.
Thank you, Renai. Dr. Anup Surendranath and dear friends, dear viewers, today's topic, presumption of innocence. Well, we are actually at crossroads because of the various legislative measures which have come over the years, really has hampered the judicial trial. Sometimes in the so far as trials of fact are concerned, they do not have a clear way ahead to finally adjudicate a matter in a in a constitutionally certain way. Now, so presumption of innocence, I would start from the beginning. See, it is just a device used in law, in the law of evidence, to enable a proposition to be taken into account as a piece of evidence in a case, even though the argument supporting that proposition is not strong enough for it to meet the required burden of proof. See, what is presumption? We can see that presumption is actually linked to the concept of burden of proof. What actually the presumption does is it shifts the burden of proof. Burden of proof actually sets a standard for what is considered a proof in evidential reasoning in law. Actually, it is a device used to make it possible for a trier of fact to arrive at a decision in a contested case. See, so far as facts are known, the facts may not be known, and for various reasons may ever be known. It will to the trier of the fact. In a criminal case, there may have been no witnesses to the crime, and the crime may have happened long time ago. Most of the existing evidence must have been destroyed. Therefore, evidential reasoning in law has to be able to move forward to a conclusion under the conditions of uncertainty. So lack of knowledge and even inconsistency. That is where the law of presumptions come in. Now, when we there is an excellent book by Douglas Walton on presumptions. Now, before going into these matters, I would just like to take you to a case law that is you all must be knowing, Bloomington's case, where Lord Sankey had laid down, or in fact, there was a paradigm shift in the matter of presumption of innocence and the burden of proof. Now, I just state the facts so that in 1935, this Reginald Bloomington was a 21-year-old agriculturist laborer. He was convicted for the murder of his 17-year-old wife, Violet. They had been married for a year and they had a son. So they separated. And after that, Violet used to leave Bloomington without his permission. He was enraged. And therefore, Bloomington became first member of the Royal Marines and Royal Field Artillery. But he was prevented due to some disease from serving on a long-term basis. So now Bloomington went to his wife's house to bring her back. But to threaten her, he says, he hid a gun inside his shirt, which according to Bloomington, accidentally went off. And the Violet died instantaneously due to gunshot wounds. Now you will find that this Bloomington's case, the law then was slightly different from what we understand. Law was understand about the presumption of innocence now. See, Bloomington, he claimed that he simply wanted to scare his wife and nothing else. And the trial at the Old Bailey, Bloomington offered a defense that it accidentally went off. So the question was it for Bloomington to prove the accident, or was it for the prosecution to rebut his claim? Who had the burden of proving the aspect of Bloomington's guilt? Now we see initially the Justice Finlay, who was a trial judge, he framed because in jury trial, the judge sums up the evidence and then gives instruction to the jury as to how they should proceed. And the burden was, he told the jury that once it is shown that somebody had died through the act of another, that is presumed to be murder, unless the person who has been guilty of the act which causes the death can satisfy the jury that what happened was something else. Then the jury went, they deliberated, and they were not able to give a verdict. Then there was a mistrial, and again a retrial was ordered. On the second time, the Bloomington's case, the trial judge, he framed the question in a manner: if homicide had happened, the trial judge told the jury that it was for Bloomington to prove that the death was caused by accident, that the gun had went off accidentally. But then it went up to the Court of Appeal. The Court of Appeal confirmed the sentence, and then before the House of Lords, it went to Lord Sankey. Lord Sankey overturned the existing law on presumptions as well as the burden of proof. He said that the burden lies on the prosecution to prove the guilt of the accused. He said that the burden of persuasion is always with the prosecution, and prosecution was bound to prove that it was the death occurred, and there was culpable mental state on the part of Bloomington. And Bloomington was acquitted. In fact, a large gathering was there to witness the second trial, and after that, in the appeal also. Now, Lord Sankey said that there is a golden thread running through the web of English criminal law, which is the presumption of innocence. Now, a person is presumed to be innocent until the guilt of that person is established beyond a reasonable doubt by the prosecution. So this presumption continued. It was accepted. This happened in 1935, and of course, we being part of the British Empire, our courts were also bound by the Bloomington's statement of law made by Lord Sankey, and we have continuously followed even after the independence. This is an oft-quoted statement by Lord Sankey that the golden thread running through the web of criminal law in our country, in all English-speaking countries. Now, after many years, we had the first caution was made almost in 1973 by Justice V.R. Krishnaiyer. He made a prescient observation in Shivaji Rao Bobde's case. Shivaji Rao Bobde was a state of Maharashtra. In that case, an old man was killed in broad daylight. It occurred in 1966 in Satara district, and two young persons, they were charged with the crime. And finally, when it went to the Supreme Court, I'll just state the words stated by Krishnaiyer, because I cannot repeat the words. You cannot memorize it and repeat because of his great oratorial and writing skills. This is what Justice Krishnaiyer said, I quote: "The cherished principles or golden thread of proof beyond reasonable doubt, which runs through the web of our law, should not be stretched morbidly to embrace every hunch, hesitancy, and degree of doubt. The excessive solitude reflected in the attitude that 1,000 guilty men may go, but one innocent martyr shall not suffer, is a false dilemma." He went on to say, "Only reasonable doubts belong to the accused. Otherwise, any practical system of justice will then break down and lose credibility with the community." He said that evil of acquitting a guilty person lightheartedly goes much beyond the simple fact that just one guilty person has gone unpunished. Now, he also said that if unmerited acquittals become general, it is a challenge to the society. He presciently said that harsher presumptions of law, because if unmerited acquittals are the norm, there will be harsher presumptions of law and such other things, which will even the innocent will find it difficult in a judicial trial to prove his innocence. Now we have, we have many reverse burden clauses in many enactments. You find that in 278E of the Income Tax Act, where it is said that presumption as to culpable mental state. So in a prosecution, under the if you don't file a return, your culpable mental state, including intention, motive, or knowledge, is presumed by the court. Prosecution does not have the burden to prove that. Now you find major Indian statutes, Section 35 of the NDPS Act, 54 of the NDPS Act. Then there is a POXO Act. It is very draconian presumption. Once the case is filed, they say there is a presumption. But then presumption of culpable mental state found in Section 30 of the POXO Act. Dowry death cases, 304B and 113B. Then Prevention of Corruption Acts. Then see, you must understand that the Parliament has laid a different standard of proof in relation to certain offenses, certain patterns of crimes. There are a large number of statutes now where the doctrine of reverse burden has been applied. And these reverse burdens have been challenged. And in many decisions, like in Harendra Sarkar's case, State of Punjab versus Baldev Singh Narcotics Act case, Maharashtra State of Madhya Pradesh versus Narayan Singh. In all these cases, the reverse burden clauses have been held to be constitutionally valid. Now the later statutes say that the reverse burden clauses have been which have stated that this presumption of culpable mental state may have to be proved beyond a reasonable doubt by the accused. I do not know what is the real standard, because beyond a reasonable doubt, if you have to prove a culpable, you have to prove that there is no culpable mental state. It is a very arduous uphill task for an accused. That is where our presumptions are going, because like the prescient warning by Krishna, unmerited acquittals, light-hearted acquittals have taken us to this stage. So now, what about this presumption of innocence? Where does it stand in the constitutional scheme? In Noor Agha's case, you might remember Noor Agha's case, an Afghan had come here. That is also relating to this Narcotics Act case. In Noor Agha's case, also the Supreme Court said that presumption of innocence is located in Article 21 because it is a human right. It is a human right under Article 21. But nonetheless, the Supreme Court did not say that the reverse burden clauses do violate the presumption of innocence. I mean, the Article 21 right. But now, as it stands, the way in which judicial decisions go, it has become very arduous task for the accused. If the burden on the accused is placed in this fashion in judicial trials, well, it will. We must go to say that it will be difficult for him even difficult for the innocent to prove his innocence. The courts have to be very, very careful in dealing with these cases, because we always used to say in the National Judicial Academy that the role of a judge is not to convict a person. Role of a judge is to ensure fair trial and ultimately render justice in accordance with the law, not to convict people, not to acquit people. Basically, this conviction mentality. Now, if you see the cases being registered by enforcement director and other investigating agencies, see, people are taken to the police stations or enforcement directorate or CBI or other offices, and even questioned for 10 hours, 20 hours, days on together. How can the accused be questioned? If suppose the accused says that I have nothing to say, the accused does have a right to silence. He is not. It is not necessary for the accused to support the prosecution case. He can always say, he can always maintain silence. If suppose the police say, we want the accused, we have to recover an article from him after questioning him. If he goes to the police station and says, I have nothing to say, can he not maintain a silence? Is he expected to incriminate himself? In Kathikalu Agad's case, 11 judges have said that even for derivative use, like Section 27 or other things, for derivative use, coerced confession cannot be used. That has been reiterated in Selvi versus State of Karnataka, the narco analysis case. So where are we going? We have to be aware of these constitutional prescriptions. See, coerced confessions, taking people to 20 hours and then questioning him for days on together. See, inherently, it is called a sweat box in the American jurisprudence, police stations. It is an inherently coercive place, and questioning a person is inherently coercive. If you spurt out anything after 20 hours or 15 hours, can you say that it is voluntary? In Lisenba's case and several other cases after Miranda, the US Supreme Court has held that continuous questioning of a person isolated in a room without his counsel being present is inherently coercive, and any confession extracted being in her coercive confession is not, even if you give a Miranda warning, it is not admissible in evidence. That is the line of thinking in the, but unfortunately, in certain decisions of our courts, the court has said that ED, especially in ED cases, no counsel's assistance is given for at the time when the accused is being questioned. So this because giving a statement to the police, as per the decision of the 11 judges, it is also a case you are being a witness. What is being a witness? To be a witness has been defined in that Kathikalu Ogad's case. Your statement given, voluntary a statement given to the police, orally or in writing, you are being a witness, and you cannot be a witness against yourself, because testimonial compulsion, the statement given to the police also come in. That is why coerced confessions can't be used for derivative purposes. Now we have to think loudly. Where is our constitution? Where are our investigating agencies, and how is our criminal jurisprudence proceeding? This is my just introductory remarks, so that you can think loudly on these matters. Thank you.
Thank you very much, sir, for those insightful introductory remarks and for setting the context for today's discourse. Before I welcome our distinguished speaker for the evening, I take this opportunity to acknowledge the presence of Honorable Mr. Justice V.M. Shamkumar, sir, Judge of the Kerala High Court, for being with us for today's function. For those who have seen the previous videos, one can understand that he has been an active member of the state unit while he was a member of the bar. Sir, on behalf of the Kerala State Unit of the Indian Law Institute, I welcome you to this discourse. Now, let us welcome our speaker for today's evening, Professor Dr. Surendranath. Dr. Anup Surendranath is a professor of law at NALSAR University of Law, Hyderabad, and the executive director of the Square Circle Clinic, an institution that does extensive work on India's criminal justice system, including providing pro bono representation to death row prisoners and under trials. The clinic's works on issues such as the death penalty, forensics, mental health, and legal aid has received both national and international recognition. Through its litigation and research efforts, the clinic has contributed to the acquittal of 34 death row prisoners and to the commutation of sentence of 53 other death row prisoners. Professor Surendranath is also a member of the Advisory Council of the Bonavro Institute of Human Rights at the University of Oxford. We are truly honored to have him with us this evening. Before inviting him to begin, may I once again remind the audience that the lecture will be followed by a question-answer session, and those joining us online may pose their questions, which will be taken up thereafter. May I now invite Professor Dr. Anup Surendranath to deliver the discourse on the topic, Presumption of Innocence, Constitutional Uncertainties. Over to you, sir.
Thank you, Renoy. And thank you everyone at the Kerala State Unit of the ILI for having me today. I also acknowledge the presence of Justice Shamkumar, who had the honor of meeting when I was earlier in Kochi. Wonderful to see you again, sir. And also all the colleagues at the Kerala State Unit. And I have very fond memories of the previous time I had spoken on this platform. So thank you once again for having me, and it's great to see everyone. Thank you, Harindranath sir, for setting that context so well. And the discourse today that I want to engage in is to invite everyone to think about the constitutional uncertainties, and the topic is self-explanatory, and as to what exactly is constitutionally uncertain about the presumption of innocence, right? And it would be my endeavor today to convey to you that there's a lot that is constitutionally uncertain and for something that is so fundamental. And from the days of Wilmington, as Harindranath sir said, it is something that we have repeatedly said is very, very fundamental and important. But unfortunately, I will try and convince you today that we really haven't been clear about the content of the presumption of innocence, right? And that's going to be my endeavor today, that there is no constitutional certainty about both the status and the content of the presumption of innocence, and that we need to build towards that. And then I'm going to try and show you what have been the consequences of that constitutional uncertainty. But before I get into that, I just want to spend some time just sort of theoretically exploring what is the presumption of innocence, and then sort of start by saying, why do we have the presumption of innocence? And if I may strongly recommend to all of you Andrew Ashworth's article in the South African Law Journal from 2006 on the 4 threats to presumption of innocence. It's one of our great criminal law theorists of our times, and it's certainly an article worth reading. That's 4 Threats to Presumption of Innocence by Andrew Ashworth. And I think Professor Ashworth does a great job of saying why do we have the presumption of innocence, and what are the different forms in which the threats to presumption of innocence have emerged over time, right? And I think very often it is considered so fundamental a principle that we don't really tease out the reasons as to why we have the presumption of innocence. The first, obviously, that it is seen as a bulwark against, it's a protection against wrongful conviction, and I think that's one of its key elements. That since criminal and Professor Ashworth invokes Ronald Dworkin on this, that there is it is grounded in a very fundamental moral and political safeguard. That the value behind presumption of innocence has a very significant moral. It is a very moral and political safeguard because criminal conviction comes along with it public condemnation and punishment by the state, along with your denial of liberty, along with the very physical consequence of denial of liberty. Dworkin argues, and Ashworth adopts that argument, that there's a very serious moral harm of punishment, and therefore both for the physical harm and the moral harm, the presumption of innocence is a strong protection against wrongful conviction, and therefore the system must be invested, and the criminal justice system must be invested and interested in preventing and minimizing conviction of the innocent, and therefore the principle that Harindranath sir was talking about. And also then that the presumption of innocence and questions of burden of proof is also based on the second justification, that criminal punishment requires very, very high justification, right? It requires very strong justification. Given its consequences, we cannot have a low threshold of proof to that. And then whom must that burden fall on? The burden must fall on the state. And therefore, criminal punishment requires strong justification. And an integral part of that is that the presumption must be one of innocence and not the other way around, right? And that there has to be very strong reasons to justify punishment. And a part of that is following very fair procedure. Underlying all of this, underlying both these reasons, that it is a check against wrongful conviction, and that also that you shouldn't punish somebody unless there is a very, very high degree of justification through proof, is the assumption, and quite the right assumption for a criminal justice system to make, that the criminal justice process is fallible, right? That there are many points of fallibility of the criminal justice system, that there are witness errors, there is errors of memory recollection, there is misinterpretation of evidence. In our system, there are very serious concerns with how investigations are conducted, how prosecutions are conducted. So there are very significant points at which the system is fallible. And therefore, the first 2 points that I was making, that is protection against wrongful conviction and strong justification, the presumption of innocence also is a check against individuals having to pay the price for a very fallible criminal justice system, right? And fundamentally, the presumption of innocence, lastly, I just want to say, is a very, very important mediating principle of the relationship between state and citizen, right? With the state, with its monopoly over coercive power and monopoly over violence, and its monopoly to deny liberty to citizens, without this mediating principle, that check on the state becomes a far more difficult task at hand. And all of that, and I think this particular feature, that it is a very important mediating democratic principle in that sense of the relationship between the state and the citizen, is something that we will get to. And as Arindranath was also saying, that you will see that being chipped away slowly in our laws, and I'll get to that later, right? So therefore, this inequality of power between the state and the citizen, to some extent, is being corrected. That inequality of power relations between the state and the citizen is being corrected through this principle of presumption of innocence, right? And I think broadly, if you see how is presumption of innocence being eroded, and I just want to have sort of three main steps to sort of categories. I just want to categorize different methods by which the presumption of innocence can be thought of as being eroded, or there are different ways in which the presumption of innocence can be eroded. And this, again, I'm just categorizing the categories that Ashworth puts across quite strongly. The first one, very interestingly and quite counterintuitively, Ashworth makes the point that presumption of innocence is often diluted by the manner in which criminalization happens, right? How crimes are defined. You see that legislatures redefine offenses by making them easier and easier to prove, by removing mental fault elements, right? As you will see that taking away of the mental fault elements and no fault liability in criminal law, right? And that kind of legislative criminalization is one method by which the presumption of innocence is being eroded, right? The second is what we might be more familiar with, is erosion through exceptions, right? Where you're saying that there are increasing reverse onus provisions, there are increasing presumptions, and there is shifting of burden. That your very explicit exceptions to the presumption of innocence, right? Third is evasion using civil or non-criminal processes, that he's talking of the regulatory offenses, right? Where there are regulatory measures in order to control behavior of individuals, or there are civil procedures increasingly instead of criminal trials, and the reason for making these regulatory offenses is that then the full force of the proof beyond reasonable doubt is not available, and those full fair trial protections are unavailable, right? So he's characterizing and he's saying that, the various moves on diluting presumption of innocence can fall into these three broad buckets. And as we get into the Indian criminal justice system, it'll be interesting to see where are we, that different things are happening in different legislations, right? And how would we characterize each of these moves on the presumption of innocence? And I'd be my case to say that it is not just one thing that is happening with the presumption of innocence in India, right? And I'll make my case to say that there are different dynamics that have evolved on how the presumption of innocence is being eroded in the Indian context. But before that, I just want to spend some time, before I get into the sort of legislative assessment of what is happening in different laws. I think there is significant confusion about the constitutional status of presumption of innocence. And what do I mean here? If I were to ask the question, is presumption of innocence a fundamental right? Right? Noor answers that in the negative. Right? Noor answers that yes, it is very important. It is there in the ICCPR. It is a fundamental protection. It says yes, it is a human right, but it is not a fundamental right. That it does not ascribe it that and if you see and of course in analyzing sections 35 and 54 of the NDPS, it also goes into 113A and 113B of the Evidence Act. It says, look, all of these things, right, are fine because there is a balancing act to be done, but the balancing act is not arising from the presumption of innocence as a fundamental right, right? And now in 35 of the NDPS Act, 35 of the NDPS Act is similar to it's that presumption on mental state, and 54 of the NDPS is on, if I may just read out, presumption from possession of illicit articles. In trials under this act, it may be presumed unless and until the contrary is proved that the accused has committed an offense under this act, right? Until the contrary is proved that the accused has committed an offense under this act in respect of any narcotic, drug, or psychotropic substances or controlled substance, right? So you're saying the burden is on the accused, and it's very instructive to see how the judges in Nuraga, and no less than one would say a doyen of the rule of law, Justice S.B. Sinha, and if you see his judgments on presumption of innocence, has consistently maintained that the presumption of innocence is not a fundamental right, right? And he's saying it's very important, it is fundamental, it is core of a society and all of that, but does not go as far as to say that it is a fundamental right, right? And he says that, and in saying that, and please allow me to read, Sections 35 and 54 of the Act no doubt raise presumptions with regard to the culpable mental state and also places the burden of proof on this behalf on the accused. But a bare perusal of the said provision would clearly show that presumption would operate in the trial of the accused only in the event the circumstances contained therein are fully satisfied, right? An initial burden exists upon the prosecution, and only when it stands satisfied would the legal burden shift, right? And sort of saying there are background facts. There are background facts that the prosecution has to establish, and only once those background facts are established, then does this shift. Even then, the standard of proof required for the accused to prove his innocence is not that as high that of the prosecution. Whereas the standard of proof required to prove the guilt of the accused on the prosecution is beyond all reasonable doubt, it is preponderance of probability on the accused. If the prosecution fails to prove the foundational facts, and of course this whole foundational facts becomes so important in the context of the POCSO as well, to prove the foundational facts so as to attract the rigors of 35, the actus reus, which is possession of contraband by the accused, cannot be said to have been established. So here, and again, when he does the analysis of the presumptions in 113A and 113B of the Evidence Act as well, he is taking refuge under the fact that the prosecution nonetheless has an initial burden to prove foundational facts, and they have to prove the foundational facts to proof beyond reasonable doubt, and only then do provisions like 35 and 54 of the NDPS Act kick in, and therefore he's saying this is not really a reverse burden of proof. And anyway, he's saying, but however, the position in Nuraga, and if you read case law on this, you will find the explicit connection saying that presumption of innocence is a part of the fundamental right under Article 21, and that comes in cases like Manu Sharma versus State of NCT of Delhi, and it also comes in Satinder Kumar Antil, right, in 2021. Again, two judge bench decisions, right, which are saying that, I'm not sure if Manu Sharma is 2. I think Manu Sharma might be 3. I can't remember accurately now. So there are judgments which also say that presumption of innocence is part of Article 21, right, as a fundamental right. But there is confusion, and it is, it would be very obvious from a reading of case law that whether presumption of innocence is a fundamental right is an area of constitutional confusion. It is not one of those areas, even on the existence of it as a fundamental right, right? I would argue that it is not so clear. What is certainly not clear is what is the content of that right, right? If we are to recognize it as a fundamental right, just like we might recognize any of the other rights, the right to remain silent, or we might remind the right to food, or whatever else. What is the content of the presumption of innocence? Right? Unless there is constitutional clarity on that. And I would want to say that the constitutional content of the presumption of innocence cannot be limited to our understanding of the presumption of innocence and its connections or its manifestation in the Indian Evidence Act, right? That cannot be. There has to be a break from when the Constitution comes into force. If we are going to recognize it as a fundamental right, what is that content of that fundamental right? Right? Of course, things like the South African Constitution in their Section 34 have a very explicit recognition that the presumption of innocence is a fundamental right for them, right? And why does this matter, right? And I think we really need to ask, why does this matter as to whether it is a fundamental right or not? And I think and that consequence of it being a fundamental right plays out in different legislations, and I'll just come to that. But I just want to take a detour into the South African jurisprudence on this, right, which is very much stronger than ours on the presumption of innocence, right? In two cases that I would like you to, if you have the chance and the interest to look at, in S versus Guadiso, that is GWADISO, the South African Constitutional Court in 1995 was involved in testing the constitutional validity of their Drugs and Drug Trafficking Act, a certain provision, which said that if you were in possession of more than 115 grams of banned substances, if you were in possession of more than 115 grams of banned substances, the law would presume that you were dealing in that substance, unless the accused proved otherwise, right? So he's saying, yes, if the fact of possession beyond a certain quantity is proved, the law will presume that you were dealing in that substance unless the accused proves otherwise, right? What might, if one were to just read Indian case law on this, one would assume that this is something that would surely be upheld, right? But it's very interesting, right, what the South African Constitution Court does in this case, and also in this the subsequent case that, if you're interested, is S versus Manamela, Manamela, the South African Constitution Court of 2000, where the provision involved in Manamela was that if you are found in possession of stolen goods, if it is established that you have possession of stolen goods, there is a presumption you have to show. Then you have to show that you did not know that it was stolen, right? Right? Both of these are struck down by the South African Constitutional Court for violating the presumption of innocence, right? And the reason for mention, and I don't want to delve too much into, and I want to make a broader constitutional point as to why, and the reason why I said I'm getting into this is to say, why does it matter whether it is a fundamental right or not, right? And that's the reason for that. Is because the moment it is recognized as a fundamental right, the South African Constitutional Court has to undertake a proportionality analysis under Section 36 of their constitution, right? And there has to be a higher order justification that the state has to provide as to why does it have these reverse onus clauses, right? And that is subject to the proportionality test. And therefore, it is for this purpose that I think that a very strong acknowledgement and a very clear acknowledgement of both the fundamental rights status of presumption of innocence and a clarification on its contents is very important, on the content of the right is very important. Because once that is done, after the judgment in Puttaswamy, it has these provisions, all these provisions that even Sir mentioned and that I'll also be discussing now, will and should be subject to a proportionality analysis, right? The state has to go through the rigors of the proportionality test developed in Puttaswamy to justify why these provisions are okay, right? And whether the legitimate aim, is there a rational connection? Was there no other restrictive measure by which it could have done it? Is the measure that is adopted proportionate to the risk that it poses to fundamental rights, right? Subjecting it to a proportionality analysis, the reverse onus clauses or the presumption clauses for violating presumption of innocence subjects the state and will force the state to have a higher order justification of why such provisions are needed across a wide range of legislative subjects, right? We see it in the NDPS, we see it in POCSO, we are seeing it in the UAPA, and I'll come to the bail provisions are another completely different set of things. What is happening under bail provisions, under special bail provisions, and what is happening to presumption of innocence. So we are seeing it, and of course the POCSO as well, we are seeing it under a wide range of legislative actions where these reverse onus clauses, the presumption clauses, right, and the bail provisions need to be subject to a proportionality analysis, which so far they haven't been done, right? And even though there is recognition of, again, as I said, you're finding contradictory judgments on whether it is a part of an Article 21 fundamental right or not. Once you recognize that, yes, it is a part of an Article 21 fundamental right, a proportionality analysis will have to be undertaken through that. And you will see how the rigors and the difficulties of justifying a reverse onus clause through the lens of the proportionality analysis becomes very obvious when you read the full text judgment of Guadiso and Manamela by the South African Constitutional Court, right? Of the nature of justification. You can't just say that, oh, it is an important social issue and therefore I must be allowed to do this, right? As a legislature, the questions are far more rigorous and it's a higher standard of judicial review, as we all know, right? It's a far more onerous standard of judicial review to undertake through the proportionality analysis. And it is, I think, if we accept that presumption of innocence is a fundamental right, it has to be put through the rigors of the proportionality analysis, right? Now I would urge everyone to sort of consider what are the different sorts of issues and what are the different ways in India's legislative framework as to how the presumption of innocence is being chipped away, right? One is like Section 54 presumptions in the NDPS, that is very obvious that the offense is being presumed unless it is proved otherwise, right? Also, the presumptions in the Indian Evidence Act, right? Then there is the presumption on mental state that you see in 35 of the NDPS, and you also see in 30 of the POCSO, right? And I think it's a and of course even on just before that, even on presumption of even of presumption of offences, just like Section 54 of presumption of illicit articles in the NDPS, Section 29 of the POCSO is also on presumption as to certain offences, which says where a person is prosecuted for committing or abetting or attempting to commit any offence. Of course, what is the exact meaning of the word prosecuted there is a separate question. when a person is prosecuted for certain offenses under the POCSO, the special court shall presume that such person has committed or abetted or attempted to commit the offense, as the case may be, unless the contrary is proved. Right? Now, even if the question really is, and unless you clarify the content of the presumption of innocence, we are challenged to see what is the articulation as to what is the presumption of innocence problem with this provision. Right? And I think the Wollington articulation is important, that and it takes us, and if I may posit or if I may attempt a definition of what will be involved in presumption of innocence, I would think that presumption of innocence, whatever else it may or may not contain, must certainly contain that the full offense is established to an extent of proof beyond reasonable doubt by the prosecution and by the state before the accused has any case to answer. Right? Now, of course, that's why I mentioned what Ashwath was saying, that what the state is doing, and and this is not just about India or South Africa or England. I think the trend that he identifies is a good one. In the good one, in the sense, it's a sharp trend that he identifies, that in the very definition of the offense, the game is in the very definition of the offense. And even if you say presumption of innocence means that first the prosecution has to establish the full offense with proof beyond reasonable doubt, the difficulty you're running in is as to how offenses themselves are being defined. Right? And therefore, here in 29, you're saying the state shall presume that such person has committed or abetted unless the contrary is proved. Right? Here, the burden on the state is not to prove all elements of the offense. Right? This application of 29 is available if you are being prosecuted for an offense under sections 3, 5, 7, and 9 of the POCSO. Right? Here, the presumption of innocence problem, according to me, would be that the state is not required to prove all the elements of the offense under those provisions, under 3, 5, 7, and 9. Before the burden shifts to the accused, right? The state is not required to prove all those elements, and that is the presumption of innocence problem. Right? You cannot have a 29 if the content of presumption of innocence were to be clarified, and I would think that one of its core elements should be that if you're prosecuting somebody for an offense, that proving all elements of that offense should be the burden of the prosecution, and they must first discharge that burden with proof beyond reasonable doubt, and only then it can move. One would find it very difficult to uphold 29, right? And as many of you might be aware, if you look across high courts, the confusion reigning on 29, how to read 29, at what stage does it kick in, what are the foundational facts, as S.P. Sinha was saying in the context of NDPS. Oh, anyway the prosecution has to show foundational facts. There is significant confusion across high courts on what are these foundational facts for the purposes of 29. Right? So in that sense, the lack of constitutional clarity allows for this kind of existence of provisions that are very, very significant chipping away at the presumption of innocence. And in that sense, I would characterize 29 of POCSO and 54 of POCSO along similar lines, right? And of course, then there are the provisions on the mental elements, right? On presumption of mental elements, and that's 29 of 30 of POCSO and 35 of NDPS, right? Presumption as to mental state. Yeah. Now I want to move to a second element of this, right? Which is bail provisions, right? The provisions on bail across, and of course, I don't want to get into the differences between the bail provisions in PMLA and say something like the UAPA, of course, even in the NDPS, right? Again, forcing us to think, right? Now, let's take the PMLA provision, for example, right? No person accused of 45 of PMLA, no person accused of an offense under this act shall be released on bail or on his own bond unless the public prosecutor has been given a chance, etc. Where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offense and that he is not likely to commit any offense while on bail, right? Now, here, what would be our articulation of presumption of innocence, right? I would say that there is a presumption of innocence violation here because my liberty is being denied. My liberty is being denied on the grounds of some version of me having committed the offense, but to a much, much lower standard, right? And this is not me then saying, oh, this is not me somehow challenging the very idea of bail and then applying for bail and rejecting of bail. That's not what I'm saying. When bail decisions are based on a determination whether you have committed the offense or not, in whatever form, right? Here to a much lower extent, right? You're adopting my point is, you are adopting a much lower threshold to establish whether some version of the offense has happened towards denial of liberty. And because you're using whether the offense has been committed or not, in whatever framework, either the PMLA says it or the UAPA says it, you are engaged in that exercise of determining to whatever extent that, oh, is there a prima facie case, or in the case of PMLA, you're asking that are there reasonable grounds for believing that he's not guilty. All of these are offense determination based considerations in bail. And when you undertake offense based considerations like this below the proof beyond reasonable doubt standard, I would think they violate the presumption of innocence, right? You can have other considerations of bail, right? The triple test or whatever else you want as considerations of bail, you can have that. But when you invoke considerations of have you done this or not, and I will adopt a lower standard for that, and then deny you bail and deny you liberty, that then should attract the constitutional protection of presumption of innocence, right? Because you're invoking offense-based considerations and you're using much lower standards than proof beyond reasonable doubt to deny someone's liberty, right? Of course, you might then say, if you then adopt proof beyond reasonable doubt standards at this stage, what is left of the trial? Yes, precisely the argument that you cannot be using these kinds of considerations for denial of liberty, right? You can have your bail law, but we really haven't considered the question. And of course, 43D5 is currently under challenge before the Delhi High Court, right? 43D5 of the UAPA is under challenge, right? Because look at what has happened And a perfect example of this is what has happened to 43D5 jurisprudence in the Supreme Court. Right? In the decision in Vatali and in Gulfisha Fatima, you see how the complete abrogation of this has happened. Because while Vatali itself is very problematic, right? Justice Khanvilkar's opinion in Vatali that we can't get into questions of admissibility and relevance and all of that at the stage of 43D5 determination of bail, whether the case against you is prima facie true or not under the UAPA, already almost gave an impossible chance to the accused. But in Gulfisha Fatima, you will see how the opinion says you almost have to take it for granted that the investigation agency's version is correct. There is a much wider door open in, again, when I say wider, it is a very narrow door. Wider door open in Vatali for the accused to rebut the prima facie case, and that door has been further shut in Gulfisha Fatima. Right? That is the recent Umar Khalid decision, right? And when you are now then more and more going towards saying that somehow in these bail determination proceedings, the prosecution, the investigation version will be treated as some sort of sanctified truth to deny you liberty on the grounds that the allegations against you seem to be prima facie true, is then determination that the offense is happening to whatever extent, right? To whatever degree, using the prima facie true standard. And once you get into that kind of offense determination using a much, much watered down standard, like the prima facie true standard, it certainly must violate the presumption of innocence. Again, all of this would depend on what is the content of the fundamental right to presumption of innocence. Without that clarity, you cannot say whether the POCSO provisions are violative of presumption of innocence or the NDPS provisions are violative of presumption of innocence, because we can't have some sort of hazy idea of what is presumption of innocence, right? Or how presumption of innocence will interact with the bail provisions in these special laws, right? Without that clarity, we can't, right? Now, the last thing I want to sort of refer to, right, is this whole interaction between the right to remain silent, presumption of innocence, and what is happening to 313 law, whatever the BNSS provision is, right? Fill in the blanks, right? Right? And how 106 is being 106 of the Evidence Act has been used, right? Again, line of cases, two distinct line of cases you will see on this, where courts, the Supreme Court's decisions itself, where adverse inference is drawn for your silence on 313. Right? Now, if there is a presumption of innocence, and if there is a fundamental right to remain silent, right, the entire line of cases, right, like Phula Singh was state of Himachal Pradesh, or Sanatan Naskar or Munish Mubar was state of Haryana, right? That line of cases, which then say that we can draw an adverse inference, right? Basis your if you don't if you don't have a statement in 313, or you don't clarify, or if you remain silent, or how they have interpreted and expanded the meaning of falsity under 3134, right, is mind-boggling as to how you can draw that adverse inference. And another route to that has been that is to invoke 106 of the Evidence Act, right, to say that yes, now let's see that that what is happening here is what is the logic of how 106 is used in the context of how 106 gets used, you're saying that certain facts were within your special knowledge. Let's say if it were a last seen witness, right? If it were a testimony of last seen, right? You're saying that it is under your special knowledge to have explained it under 106. So therefore but you have kept quiet under 313, right? And therefore you have not discharged this burden that you had under 106, right? However, many judgments, right, and these line of problematic cases on how they read 313 and how they're using 106, right? Almost, and that's what I'm saying. At the crux of the presumption of innocence should be the obligation on the prosecution to establish its case beyond reasonable doubt, right? It cannot be, right, run into the problem that the House of Lords judgment in Risa Shipping was trying to solve and solved very well, right? And if I may urge you, even though it's not a criminal law case, may I please recommend very strongly that you read the 1985 decision of the House of Lords in Risa Shipping, right? In Risa Shipping, they were saying that, when you understand the question of on whom is the burden and what is the burden on party A to establish their case according to the required standard of proof is independent, right? Is independent of whether the other party could come up with a better explanation or not, right? You have an independent burden to establish your case. Your argument cannot be that they don't have a better case than me, right? And therefore, in this sense, the way this whole 106 point is playing out, right? And there is another line of cases which read this 106 case law, this 106 position quite well in the Supreme Court. That's Nizam versus State of Rajasthan and Dinesh Kumar versus State of Haryana. Dinesh Kumar is 2023 and Nizam versus State of Rajasthan is 2006 Supreme Court, right? Where they say that before we get to 106, we have to first establish that the prosecution has discharged its burden on that beyond reasonable doubt. You can't now come to 106 and say that, oh, if you can't come up with a better explanation, we are going to buy what the state is saying. Whether you will buy what the state is saying is independent of whether the accused has a better explanation or not, right? Now, all of this goes back to saying this adverse inference that you seem to be drawing and what positions you must take either on how you are reading 313 or how you are reading 106 without a constitutional framework, right? It becomes very difficult. Without a constitutional the reading of 313 and the reading of 106 has to be tied to some specified constitutional content of presumption of innocence. Without that anchor on what is the constitutional content of the fundamental right to presumption of 106, we will just keep going into more and more dangerous waters on both judicial interpretation of these things and what legislatures are being allowed to do, right? Okay, so that's been my 45 minutes. I will stop there and hopefully we will pick up some of these issues in conversation. Thank you.
Thank you very much, sir, for that illuminating and thought-provoking discourse. So we'll now move to the question-answer session. We'll take up a few questions from those posted in the chat by participants who joined us online. So one of the questions that we got is that when statutory frameworks such as the PMLA, NDPS Act, and anti-terror laws dilute or reverse the presumption of innocence, resulting in prolonged incarceration of the accused, does a subsequent acquittal create a constitutional obligation on the state to compensate the individual for the deprivation of liberty suffered in the absence of that foundational presumption?
Yeah. Yeah, no, it's a good question and a tough one, right? Does again, I would ask, what is a wrongful conviction, right? And I think the court hasn't, haven't had the chance to clarify that. Actually, 3 of our death row acquittal cases are now pending before the Supreme Court for compensation for wrongful acquittal, right? Because the discourse on what amounts to a wrongful conviction, right, is just not there, right? What is so there is lack of constitutional clarity there, right? Even if now, but does the presumption of innocence increase the risk of wrongful prosecutions? I would absolutely agree, right? And that is why I started with the Ashworth framework as to what are the reasons to have a strong presumption of innocence framework, right? It is to ensure that the evidence that has been gathered and the evidence on basis of which prosecutions are being carried out stand a certain rigorous scrutiny. Now, that rigorous scrutiny, right? Again, now the denial of, and now give and because we are not tying presumption of innocence to, let's say, something like 43D5 of the UAPA, there is no bail, right? It's ineffectively impossible to get bail, right? Right. And then when you map that onto the very high acquittal rates under the UAPA or the low conviction rates, it presents the problem in its fullness to you, right? You have a very draconian bail provision, which is being routinely used and is being applied, but then you're resulting in it's resulting in very low conviction rates, right? Yes, you have, I would think, very unfairly denied liberty if you didn't have a good enough case, right? Then that's what's happening. You were able to keep people imprisoned with a lower standard of proof, right? You are able to keep people imprisoned under a lower standard of proof. That's what's happening, right? Because very often in these cases, you don't have the proof, or the proof is not good enough to meet the higher standard, right?
The next question is like a follow-up to what
I would just like to add something to this.
Yes, sir.
See, it would be actually opening up a Pandora's box, right? If there are ever so many acquittals, wrongful convictions, wrongful acquittals at various stages, and if you say that the persons who are in jail, unfortunately, should be paid compensation by the court, there may be Supreme Court is not right because Supreme Court is infallible.
Because it is supreme.
It is supreme. It is just supreme.
Yeah.
So you can't open this Pandora's box and start giving compensation to people who have been wrongly convicted, and then there will be thousands and thousands of cases.
But sir, that's
something
But for me, sir, that
no jurisprudence, no justice system in the world, because of wrongful conviction, the state has paid compensation. I don't think so. I've not come across any decision.
No, that
is, but then there could be a law or something by the state. But you cannot also say that because of the wrong placement of presumption or because of the draconian law, he has been convicted. There is a law.
No, I'm not saying on that compensation. I'm saying that if we accept the fact that I'm not saying all acquittals are wrongful convictions, right? I'm not saying that, right? But within the category of acquittals, there you will have to, I mean, shouldn't we be able to say that which of those are wrongful convictions?
Who's to say that?
Yes, but that is to be done on an assessment of, if you see some of these judgments, they're saying that it is very clear that the cops have fabricated the evidence, right?
That is a different thing.
No,
so
but,
you can see, you can file a case.
No, so even in let's say the Akshardham case, right? When acquitting,
see the penal code itself, Bharatiya Nyaya Samhita itself provides, if you are wrongfully prosecuted and the case ends in discharge or acquittal or something, malicious prosecution can always be
no,
initiated.
I'm not on malicious prosecution, sir. I am on that
But
you
to
have
say,
gone in.
but to say that there is there should be an acquittal. We have a inference that the acquittal is wrong,
No, I'm
and
not
then
saying that.
start paying compensation because the burden has been placed
No,
wrongly.
I'm not. So I'm saying that let's say something like the Akshardham case where two courts gave death sentence to these four men, and the Supreme Court finally found on its own assessment of evidence that this is a clear case of fabrication, right? And manipulating the evidence, right? Then to expect these individuals to now go back and litigate this in the trial court and not compensate them for wrongful conviction is, and exactly, I mean, when these four individuals filed for compensation, Justice Deepak Mishra gave exactly your argument, right? His was, this will open the floodgates, right? And that is for me for a Chief Justice of India to say that is a very interesting admission that we are sitting on a floodgate of cases of where there is manipulation of evidence, right?
It will be dynamite. There will be a lot of
Yeah. So, right? It's to say that there are hundreds of such cases waiting to come through the floodgates is a pretty damning admission for a Supreme Court judge to make. And he's correct. I agree. He is correct, right?
So there is one question that has been posted in our YouTube channel. So could you please tell us if there are any case laws from South Africa that have upheld the reverse burden clause? What factors satisfied the proportionality test there?
Yeah. No, there are cases where they have. I think on their Customs Act, they have, and they've said if you go through the proportionality analysis, they are saying that all reverse onus clauses are unconstitutional, right? They are saying how you design the reverse onus clause and what are the provisions of it, that is what we are going to test on a legislation basis, right? So the South African Constitutional Court does not take a principled position that all reverse onus clauses violate the South African Constitution, right? So in different cases, they assess this. And I think there are a couple of cases on their Customs Act that whatever their customs law provision is, that have upheld this, right? Yeah.
In fact, in the United Kingdom, there is the reading down approach, which you will find in R versus Lambert, 2001.
Yeah.
And also Canada, they call it the Oaks test.
Yeah.
So I just don't remember the citation. US, there are these affirmative decision cases, which I think that also, if you search you will find that.
Yeah.
So many jurisdictions have read down this reverse burden
Reverse,
process.
correct. Yeah.
That is, but our Supreme Court has not done that.
Exactly.
Like what Dr. Anup said, they have not done that.
Yeah. Because I think it's as Sir was saying, right? It's important to see the design of the reverse onus clause. It's not to say that all reverse onus clauses are bad or whatever.
Yes.
It's constitutionally impossible, right? It is to say, what is the reverse onus clause, right? What is it doing? Something like the 29 POCSO for me is a no-go.
No,
right?
as you said, 29 POCSO, the moment you file a charge sheet,
there
is a no.
That's
absolutely.
Yeah.
So there is another question. Is it possible for the presumption of innocence to survive in a functioning democracy when the very concept of innocent until proven guilty is so frequently at odds with the instantaneous judgment of the populist majority?
Well, I think the legal profession is, I know those of you who are, is a constant exercise in optimism, right? So, it's, one would hope that better times are, if not around the corner, it is on the horizon, right? So, yeah, I mean, look, things don't look good, right? And as Harindranath Sir was also saying in his introductory remarks, there is a legislative expansion on all these kinds of clauses, right? And there isn't sufficient constitutional discourse to push back against this, right? So I'm not saying that things are looking bright and rosy. They're not, but on this front, sorry, I don't have anything positive to add other than these vague things on this. Yeah.
Harindranath sir, do you have something to add to this question, sir?
Well, I'm just same opinion. But see, because of this unmerited acquittals, which are rampant, as I said in Shivaji Rao Bodbai's case, that is a prescient remark by Justice Krishna. That is happening. They have brought in harsher presumptions. Now, this is a court's own making that we have been very lax in certain matters. Investigations are haywire. So, in a mature democracy, we'll hope that this will improve, as Dr. Anup said. It has to improve.
Sir, we do have a few more questions, but due to paucity of time, can we go ahead with the concluding remarks?
Sure, I think it would be.
Sure. Thank you. Thank you so much.
Thank you, Professor Surendranath and Senior Advocate B.G. Harindranath, sir, for engaging with the questions and for those insightful responses. We will now proceed to the concluding remarks. It is my privilege to invite Advocate Mitha Sudhindran, Advocate at the High Court of Kerala, to deliver the concluding remarks. Over to you, Mitha.
Good evening. The pleasure is all mine. I'm extremely privileged to have participated in this discourse, from where Senior Advocate B.J. Harindranath started off with the history of the burden of the proof, the presumption, and how judicial precedent has treated this presumption, to, I think, how Professor Anup has underscored that the essential uncertainty is the fact that the Constitution does not even deal with the presumption of innocence with the clarity that it does deserve, or that considering that it is a bedrock of our criminal trial system, that it should have been a more certain part of the Part 3 of our Constitution. And also how it has overflowed into other parts of the criminal trial, starting from dampening the right to silence for an accused to maintain silence, and flooding into how 313 CRPC has been used instead of as a fundamental protection for the accused. It has been turned into an adverse inference for an omission to explain something which, even if that person is innocent, would probably be unlikely for him to have explained. I hope I'm speaking for all when I say that Professor Anup has convinced us, from the pretrial detention that punishes before conviction to the court of public opinion that today is amplified by digital media, and that the rise of preventive laws that essentially prioritize state convenience and security over liberty, that the presumption of innocence is too often treated as a mere technicality rather than a substantive right, a fundamental right, which ought to be protected under Part 3. And that clarity should also extend not just to its status as a fundamental right, but to the width and breadth of such a right. What should the presumption entail? I feel as I would like to end this conversation, I hope everyone here has been able to see the interconnection between the criminal law and the constitutional law, and how we have often been overlooking it. And as all of us as lawyers and people within this profession, I feel that this is something that we should all be focusing on. How crucial simple things like the presumption are, and that the Constitution's overlook of that is something which has been impacting our democracy and our trial procedure from the very beginning, which is something that we should be looking at least when we're going forward now. As we leave this discourse, I think we must carry a singular sobering thought, where if the presumption of innocence is so brittle, then no one is truly free. I would like to thank the speaker, Professor Anup, for taking the time out. I have had the personal opportunity of working with him to show that the presumption of innocence should be stronger in a few matters in the High Court of Kerala. And I'm extremely pleased to say that it's not very often that you see academics who get down to the field and actually make sure what they are learning or what they're teaching does transform into real action. And I would like to say that the team that Dr. Anup has built has been doing that, and they do that with our criminal jurisprudence. I'm sure everyone who's following the precedent that comes out knows that Project 39A, which is now the Square Circle Clinic, has played a huge role in developing the criminal jurisprudence. That's all I have to add. I'll leave it to Renoy to thank all the organizers and the speakers for joining us today.
Thank you, Mehta. Thank you.
Thank you, Advocate Mehta, for those thoughtful and insightful observations. With that, we have come to the end of today's program. On behalf of the Indian Law Institute Kerala State Unit, I extend our sincere gratitude to Professor Dr. Anup Surendranath for delivering this engaging discourse, to Senior Advocate Sri B.G. Harindranath sir for the introductory remarks, and to Advocate Mehta Sudhirendran for the concluding observations. I also thank the honorable judges who have attended the program, respected senior advocates and members of the bar, respected president and members of the executive committee of the Kerala High Court Advocates Association, professors and students from various colleges, and all those who have participated in today's program. Thank you and good night.
My particular thanks to Advocate Parvati Menon also for coordinating this all through, and Unikrishnan sir as well. Thank you so much.
Thank you.
Thank you so much. Thank you. Bye. Bye. Good night.